Hello everyone, today I'll be sharing another legal story with you. So what happened on 25th August 2025 is that the Supreme Court was dealing with the case of Vasant Sampath Dupre versus the Union of India and another. Right. So in this case what happened was that Dupre, that is the petitioner in the present case, Vasant Sampath Dupre, he was awarded with the death sentence by the Sessions Court for the rape and murder of a 4-year-old girl child. Right. So Dupre was convicted for death sentence. Thereafter he filed an appeal to the High Court, and the respective High Court affirmed the decision of the Sessions Court. Basically they affirmed the death sentence. Thereafter the aggrieved, he approached the Supreme Court. So Dupre approached Supreme Court, where the 3-judge bench affirmed the decision of the High Court. So again that sentence was upheld. Thereafter a review petition was filed, which was dismissed. Right. Then a mercy petition which was rejected by both the governor as well as the president. Right. Subsequent to this, presently a writ petition is filed under Article 32. Okay. So a writ petition is filed under Article 32 presently, right, where when the question arises whether the petition under Article 32, writ petition under Article 32 is maintainable or not in the present case. So in this case basically the petitioner contended that whether the guidelines, right, that were given by the Supreme Court in the Manoj versus State of MP would be applicable to his case. Right. So to this the respondent objected that the filing of the petition, he objected the filing of the petition under Article 32. Right. So he objected since the order of the Supreme Court has already attained finality. So since the order already attained finality, there is the petition under Article 32 is not maintainable. This was the contention of the respondent, and respondent also said that the petitioner is only left with the remedy of the curative petition. At present he is only left with the remedy of curative petition. Right. After hearing both the petitioner as well as the respondent, the Supreme Court said that the writ petition is allowed. So the Supreme Court allowed the writ petition under Article 32. Right, stating that the Article 32 empowers the Supreme Court to reopen the matter at the sentencing stage. So the court can reopen the matter at the sentencing stage in cases related to capital punishment, right, where the accused has been convicted to death sentence without following the guidelines that were held in the Manoj versus State of MP. Right. So the Supreme Court said that the court has the power to reopen the matter, right, at the death sentencing stage, right, in the cases where capital punishment has been granted, right, without following the guidelines that were held in the Manoj versus State of MP. Right. This is what the Supreme Court said. The court also said that the corrective power that is the Supreme Court is exercising under Article 32 is invoked precisely, right, is invoked precisely to compel the rigorous application of safeguards held in Manoj case. So basically the Supreme Court is exercising its corrective power under Article 32 in order to enforce the guidelines or the safeguards that were held in the Manoj case. Right. Court also said that the direction in Manoj case, right, would apply to the present case, that is of Vasant Sampath Dupre versus Union of India and another. Right. So the court also cautioned, at the same time the court cautioned that in cases of matter that are concluded, in cases of concluded matter, the court cannot routinely reopen the matter. So it is not a matter of routine that the court will reopen the matter when the petition is filed under Article 32. Right. Only in the cases under Article 32, okay, where the relief is reserved for the cases where there has been a breach of procedural safeguards. So in cases where there is a breach of procedural safeguards, then only in that case under Article 32 the concluded matters can be reopened. Right. Only in that peculiar scenario itself. Okay. Not in all the matters the court will reopen the matter. Right. The court maintained the conviction of the petitioner. Okay. So the court maintained the conviction of the petitioner, but they set aside the 2017 view taken on sentencing. So court set aside this view, that is the 2017 view that is taken on sentencing. At the same time the court maintained the conviction. Right. And the court conferred the matter before CGI for appropriate listing. right, so that the matter can be heard afresh on sentencing in conformity with the Manoj case, right. So the court reserved the matter for appropriate listing so that the matter can be heard afresh on sentencing and in conformity with the guidelines or the safeguards held in the Manoj case. Okay, thank you so much.